It's gonna be a long conversation. Where did he throw it away?
There was a little bit left. I used
I
it,
know.
and I disposed of the tray.
You what?
I used it and I.
Oh, you
disposed of the
used
tray.
it then. Okay, so
There was only a little
it
bit.
didn't stay on the tray. Right.
And I disposed of the tray.
Yeah. You take it any way you want.
Ready, Judge.
Yeah, Jonathan Lemons on behalf of the people.
Workshop Feaster, Assistant Public Defender, Mr. Walter LaCroix. Mr. LaCroix, please state your name for the record.
Walter LaCroix.
Thank you, Judge. I have spoken to Mr. Emmons about this case. It's going to do some further look at the matter to see where we stand in terms of an offer. We're asking just for an adjournment for a couple of weeks of the PCC. And then I need to address his, it's not a bond violation yet, I don't believe, but it's a bond report where Mr. Croy given permission to test in Genesee County. He signed up for a program, DNA testing in Genesee County. That program did not release testing results to the community corrections unless he was
Well, hold on a second. That's not what I have. Do you have his progress report?
The one that I have, I do have a progress report.
From August 28th?
I don't believe that's the date. Let me check.
Mr. Allen?
Yeah, mine dated August 28th.
In terms of his testing, I have so he's here on an operating while intoxicated causing death.
That's correct, Judge.
All right, and on August 20th, after his arraignment, what day was he arraigned?
I believe he was arraigned on the 16th.
So then he got tested on the 16th he was ordered. He wanted to test there. He tests on August 20th, and he's positive for cocaine.
Correct, Your Honor. I'm aware of that.
Then on the 22nd, he didn't appear for his testing.
That was when I was setting up to be tested in Genesee County. I didn't have to test again because I had just tested. I was just signing up to test in Genesee County. And I called the lady down here to let her know right away.
All right. Let's go back a moment because I don't think he's been before me.
I don't believe so, Judge. Just asking for a 2-week adjournment to see where we stand in terms of the potential.
Why is he testing positive for cocaine after getting charged and arraigned on an operating while intoxicated causing death?
Because he used cocaine, Your Honor. Obviously. I don't think he's.
No, it's a fair answer to my question. I'm just saying why.
Yes, Judge.
Why? I mean, why is he using anything?
Well, my understanding is he is not any longer.
What?
My understanding is he is not any longer, but he previously was. He began testing, transferred that testing to Genesee County per the instructions he was given at arraignment. He's been testing there, but they are not reporting the results here unless he is positive. They have not called him to test this week. He's called them twice a day to go test. They have not called him, so he went over today to community corrections and tested here. And he is going to change if the court allows.
He tested here today?
Here this morning.
What is it? Do we have results on that?
I don't have it.
I don't have anything yet,
I was
Judge.
informed about it this morning myself.
So, go ahead, Mr. Green.
Thank you, Judge. So rather than do the Genesee County testing that authorized to do that does not send the reports as community correction would require, he has signed up again today to test here and do all of his testing here, although he does not live here. He has a relative here with him who has agreed to drive him back and forth. To do that testing, if he is allowed, Your Honor. I understand.
What was the intoxicant in the primary offense?
Cocaine.
So let me get this right. I just want to make sure. So I have it clear in my head.
You do.
He was charged with operating while intoxicated, causing death.
Yes, Your Honor.
The intoxicant in that charge is cocaine.
Yes, Your Honor.
He's in arraigned. So now he knows what he's charged with.
Yes.
He's told to go to community corrections. When he gets to community corrections, mind you, 4 days later,
Yes. He tests positive.
he tests positive for cocaine.
I had some at my house, which I disposed of.
In your nose or what?
I had it in a tray and I disposed of it.
You what?
I had it in a tray
And
I
then you
threw
just
it away.
smoked it.
I threw it away.
You threw it away? How's that work? Where did you throw it? It's gonna be a long conversation. Where did you throw it away?
There was a little bit left. I used
I
it,
know.
and I disposed of the tray.
You what?
I used it and I.
Oh, you
of the
used
tray.
it then. Okay, so
There was only a little
it
bit.
didn't stay on the tray.
And I disposed of the tray.
Yeah. Yeah. Okay, well.
And since then, I haven't touched it since.
What's that?
Okay, he probably stopped using because he's coming today. And yeah,
I'm printing them now.
you're printing them.
I haven't touched it since.
So somebody needs to answer for me, why was he using after being arraigned
I mean, obviously,
on this charge? And why was he using?
I don't.
I have my theory, Your Honor.
I don't think there's any answer to
Oh, darn.
satisfy the court as to why.
And by the way, you're still using.
Honestly, I don't see how. I
Oh,
have-
really? Hold on.
I've been with my
You know what?
cousin.
The thing I hate more than anything is when somebody lies to me.
Honestly, I'm not.
Okay. Well, just make sure that you, because it has to be in your system in order for you to test positive. And if it's been fine.
Council, approach briefly. You want to see this? That's my copy though. Yeah, this is the one he took today. No, not at all. We need all of this on the record.
And the last positive, 22nd to 7 days later.
Yeah. 7 days later. And a little bit he threw away.
Okay.
Go ahead, I'm sorry. I'm messing up your story.
Oh, I know. But all I've done is I've used it in the chair that I saw. I've used it in the chair. And that was it.
When it's second.
No, I have not.
Okay. Well, we'll tell them that, but, you know, medically.
I know. I want to do this. I want the truth.
Okay.
To
answer your previous question, Judge, why?
Oh, he's positive for cocaine.
Judge.
And so that we know.
Thank you, Judge. And to answer your previous question as to why he's still using after being arraigned,
Sure.
clearly he has a problem, Your Honor. There's no answer I can give you that can justify use of cocaine after arraignment when it's an illegal. He doesn't have any type of special license to allow him to use cocaine, Judge. So clearly he has a problem. He is willing to fix that problem when you test him there. He is working and he did voluntarily come here today and take a test. So he's asking you to not say that.
Right. No.
No, you have to stay.
Right, anything else?
All I can say, Your Honor. What me say?
You just tell you the truth.
Okay.
My cousin doesn't allow anything.
There's no way to put it in your food and drink.
It's possible. I have friends at my mother's house where I'm cousin's house to do work down there. Okay. Because I'm gonna eventually reside down at my cousin's house.
All right. So to the positive test, Your Honor, I have no explanation, aside from what he already told you.
Which positive test?
The
The first one or this one?
The first positive test. Your Honor.
Oh,
The
okay.
explanation he gave you is that he used it and then threw away the tray. After he was arraigned, after he was ordered not to use, have no explanation, Your Honor. He'll just ask for mercy from the court on that, and he is willing to get any treatment that the court would allow him to take place.
Because that he can't follow the court's order. I don't know how he's gonna do treatment. And the other thing is, he doesn't test when he's supposed to test.
Yes, Judge.
So it seems to me I have two options. I could let him go and say, oh, well, best wishes. Or what I can allow him to do is go back out there, use some more cocaine and kill somebody else. I'll let you know. Not doing it.
Understood, Judge.
Defendant's bond is revoked. Defendant's remanded to the Washington County Jail. I'll set his hearing September 12th, 2024, 9 a.m. for probable cause.
9/12.
9/12.
Thank you, Judge.
You're welcome. Court does call the case. People versus Jade Lathan.
Kenneth Overwater, Assistant Public Defender on behalf of Ms. Lathan, who is approaching.
Your name, ma'am?
I'm J. Ruth Bay, the nationality of Moorish American, beneficiary of the Principal Jade Lathan, and I'm making this special appearance at District 15, Michigan Court of Law under threat, duress, and coercion. I'm asking the prosecutor to dismiss this case on the grounds that there is no injured party. Plus, I have the right to a speedy trial, and this is the 5th time I've made an appearance for this in the case in the court of law since February 2024 for the arraignment. Since the arraignment, when the Ann Arbor Police Department apprehended me unlawfully and kidnapped me, forcing me to take fingerprinting and a mugshot when I am not a criminal. Officers Morgan Parker 15400 and AA Condolis 02002 claimed I fit a so-called description and also violently attacked me and produced a false police report against my person. These officers falsely accused me of committing crimes that the tapes do not show me doing at all. These tapes do not show me doing at all any of the things that I'm being accused of, as I've never harmed another person in my life and certainly not an officer of the law. I have also not disturbed the peace, and I have on file with public defender Kenneth Overwater right here to my left, a character letter from my former teacher proving that I've always been a well-behaved student, and have always gotten good grades and have no history of foul play or violence, which is still true to this day. My legal representation on the day of the arraignment on February 2024, who helped grant me my freedom on bond, has already stated on the record that I have no history of violent offenses, which is the truth. And I assume why I was granted my freedom from police custody. I would lastly like to say that on March 11, 2024, I was denied 2 main sources of evidence for my case via my personal FOIA request that would have easily shown my innocence. These 2 things are the mobile gas station cameras, and that will show the young boy already on the phone when I walked into the gas station. But either way, I was not at all acting out of the ordinary or belligerent. I was nothing but kind to everyone in that store. And I'm nothing but peaceful, and I'm saddened that I have been accused of behaviors that are not true. And I would like to exclaim that I'm a victim of a false 911 police call when I had no idea I only know that because of the police report that I got after the fact. I humbly ask both the prosecutor and the judge that this case be dismissed because I have school and I have church to attend, and my college studies have already began on August 26th at the community college. And I'm asking you to grant me my justice from this, taking up my time, because my time is very valuable to my community and I would once again like to motion to settle this case for full dismissal in a speedy manner, because this case has already been in default judgment since the date of March 7, 2024, and I yield.
All right, so that we know that the review of the court's file, I've heard everything that the defendant has said. Court's review of the file, that none of the requests to adjourn were at the request of the people. It was always at the request of the defense in terms of any delay in these proceedings. Secondly, I do not need a response from the people. If I consider that a motion to dismiss, that motion to dismiss is denied. Where do we need to go now, Mr. Overwater?
Just be asking for an adjournment of the probable cause conference.
Any objection from the people?
No, Your Honor, I have offered a misdemeanor offer of 1 count of attempt resisting obstructing the police. I'll leave that offer open to the next CCC.
September 19th, 2024, 9 a.m. In this matter, thank you.
Thank you, Your Honor.
But, you know, it really bothers me that people in my situation are given the short end of the stick on every.
On what short end of the stick have you gotten on this case? Claim in this case.
At this point in time, there is an outstanding balance of $6,307.50.
Okay, and Ms. Kurtz,
Yes.
how are you intending on trying to resolve this, ma'am?
Well, I received a summons that said the balance was 2090. And that is what that wasn't what I thought it was, and what she says really sounds more accurate. But I've had an ongoing issue with this. I've been here for 6 months, or shortly over 6 months, just 5 months and like a week. I came to extended stay and I paid a week, and then I paid another week, and then I had to pay like day by day based on the work that I do. This is like outside of conventional housing, so you can pay by the day or 2 days or by the week. The policy of extended stay is to you become tax exempt after the 30th day. So on about May 15th, I started April 15th. On about May 15th, I began to inquire about that. And I was told at the front desk that they would have to link the reservations together in order to give me the tax exemption. So I thought that's what would happen. However, when I went down to the front desk to have that put in place, the clerk was not there. So I had to wait another day. And at that point, I wasn't given like a definitive response as to whether they would be linked together or not. So I called customer relations. They said that they would recommend that the front desk link the reservations together. At that point, that was about May.
Right, ma'am?
Yes.
Have you talked to an attorney?
Have I talked to who?
To an attorney?
Yes, I have talked to an attorney. It's very interesting what happens in Michigan, because they don't necessarily treat this as a typical rental. So I called legal aid on when this first happened, and they said that there was nothing they could do.
Okay.
But it's been an ongoing problem, especially I haven't been given my tax exempt status. I wasn't given my tax exempt status, and that's what this is all based on. When I requested my tax exempt status, I was told that I would have to leave. So I'm dealing also with an unfair, possibly illegal eviction, because the front desk.
So ma'am, are you going to get an attorney?
If necessary, or I can go to trial. I'm not sure what options I have at this point.
All right. I'd suggest that you might want to get an attorney if you're going to be dealing with those issues. So I'm going to adjourn this out. I'm going to give you the 1 week adjournment to the 30th.
Sir, Your Honor, I would rather actually go to hearing, because much of the information is too complicated for this court. because there's a lot of
You'd like to
extenuating
do what?
circumstances. Excuse me?
What did you say?
I would like to move to a hearing because a lot of this is too complex for this court. There's a lot of extenuating circumstances that I'm unable to present in the time frame apparently that we have.
Okay, I mean, it's complicated. I'm a lot smarter than I look, but okay.
No, I
I'm
don't, I'm
gonna,
not
I
talking
think what I'm
about,
saying,
I'm not
ma'am,
talking
is
about
you're going to, are you gonna represent yourself on this?
I may need to because there is no attorney based on Michigan's law that
All
will
right,
allow
then
me to
here's
have
what I'm gonna do.
representation.
Here's what I'm gonna do. I'm gonna need you to file a written answer to the complaint so that everybody knows what we're going to be dealing with. I will still keep that adjournment date. I'll need that written answer both to myself, also to counsel for the plaintiff. You'll need to file that. I'll set the next hearing for August 30th, 2024. What time? 2 p.m. in person. So I need a written answer. You need to get that to counsel. That written answer needs to be in by the 29th.
Now, a written answer to what?
To their complaint for eviction.
And what will be the next legal proceeding after my written answer?
I will make that determination once I can see the written answer and make sure that
Okay.
all of the issues are in place.
And am I able to, at that point, present all of the evidence and all of the documentation?
That won't be happening at that proceeding. Ma'am, I have to get the pleadings in order. You raised certain defenses apparently to this orally. I need those in writing so that I know specifically what you're talking about and what your claims are, and so that opposing counsel also knows.
Okay, and I should have supporting documents for that?
Pardon?
And I should have supporting documents for my,
Yes, you should
Okay.
file that answer by the 29th. We will have a hearing then on the 30th.
at 2 p.m. in person.
Yes, ma'am.
All right, I appreciate it.
Thank you.
Thank you.
Thank you,
All right.
counsel. Court calls the case of ESA Management versus Elizabeth Kurtz. You can stand right up here. Hello. All right, where are we on this case? I think we were at 630750 last time or something along those lines.
If I can say something.
Yes, ma'am.
I work hard. I live outside of conventional housing. I was laid off about 10 years ago. And since that time, I've built a business. It's a street business where I sell street paper. And I don't receive any state aid, government aid, Section 8 or anything like that, but I have been able to maintain housing, especially at the extended stay. I don't have any representation because the legal aid system really doesn't support or represent who are staying in hotels, because the Michigan law is pretty vague on hotel stays when it comes to tenancy. But I would extend stay. It is a hotel that gives you, after 30 days, it gives you tax exemption. And
You were supposed to file a written answer.
okay, I understand that. Actually, I did. And I sent it to you. I mailed it to you. And today I recognize that it had gone to the wrong email. And I have documentation for that.
You emailed it to me?
I sent it to you, but I didn't know it was rejected until I was preparing today, shortly before I was preparing today.
Okay, did you get it to counsel?
It's in my phone, it's in my documents.
No. You sent something to the court. Did you
Well,
send?
I sent it, but it didn't arrive. because-
Okay, not my
Actually,
question,
didn't send it.
not my question. Did you send it to opposing counsel?
Who was opposing counsel?
Counsel for the plaintiffs?
I wasn't aware that I needed to do that.
Oh, forget.
And that's what bothers me. You know, I live outside of conventional housing. It's hard enough to stay afloat. There's not a lot of legal representation. I'm having to put together everything.
Ma'am. Yes, you're gonna have to put it together on your own. We're giving you resources to contact. You can contact the University of Michigan, you can contact whomever.
Sir, I
But-
contacted the University of Michigan, in past cases. They were unable to represent me, specifically in a case like this. Legal aid does not represent.
So you're gonna have to represent yourself.
Absolutely. That's why I'm here.
Then I need a written answer,
Okay,
and it needs to be sent to opposing counsel.
okay. Can you give me additional time to do that? Because I can't do it here because I don't have.
What is the monthly rent?
Actually, it varies, and that's the reason I'm here, because I'm supposed to get my tax deduction after 30 days.
Counsel, what is the monthly rent?
Your Honor, it's on average 84 cents a day. And at this point,
I'm sorry, you broke up there. It's how much per day?
$86.44 on average per day. And it is the outstanding balance as of today, August 30th, is $9,539.
Yeah, I have had, gradually, the fees that have been added into the account. I pay much more than 84 a day. I have, a receipt here that for,
Ma'am,
was $1,083, and that doesn't represent a lot.
ma'am, I'm going to need you to give in writing all of your defenses to this action. A copy of that answer needs to be sent to counsel for the plaintiff.
I have received that address today to where it's at.
It should be on your pleadings that you received.
I received a summons. And
In the
I
final
received
case,
notice to
a
quit.
woman named Elizabeth Kurtz is fighting an eviction
no.
from an extended stay hotel. She claims she was supposed to get a tax exemption after 30 days, but the front desk never processed it. She owes over $9,500. She says she can't get legal representation because Michigan law is vague on hotel space. The judge tries to help her, telling her to file a written answer, to contact the University of Michigan for help, to send her answer to opposing counsel. She keeps making excuses. Finally, the judge orders her to pay $86.44 per day into escrow, payable every 7 days. She says she can't pay. The judge cuts her off. "Do not interrupt me again. That's my order. The message is clear. If you want to fight an eviction, you have to follow the rules. No excuses."
To pay rent or vacate premises.
Okay. And do you see where it says plaintiff's attorney?
So if you.
Okay, look on the left-hand side, look on the right-hand side,
On the summons or on the.
on the summons, at the top.
Yeah. I see the plaintiff's name. I don't see necessarily a phone number. There's no email.
For Pete's sake. Hand me your paperwork.
I don't see any email. I'm glad to be. I didn't-
Right here. There's a phone number. There's an address. You can call them. You can get an email address that you can send it to them. But you need to file an answer. You need to file an answer and you're operating on borrowed time. Counsel, I apologize for this. I would ask your opinion on this, but I'm going to do it this way anyway. You need to file an answer by September 5th.
I appreciate it, Sean. But, you know, it really bothers me that people in my situation are given the short end of the stick on every.
On what short end of the stick have you gotten on this case? Tell me one that you've gotten here. Ma'am, I've given you a week to get representation. The very fact you could not find it doesn't put you on the short end of the stick. I then told you that what you'll have to do is you'll have to represent yourself. You said fine. So I'm telling you how it's going to run. You are not getting the short end of the stick from anybody in this courtroom. And I resent you saying that about what happens in this courtroom, because anybody that comes into this courtroom doesn't get the short end of anything from this judge. So I'm done even addressing that. You will have an answer into the court to opposing counsel by the 5th. I will set a next hearing in this matter for September 6th, 2024 at 3 p.m. I'm also going to order escrow to be paid at an amount of $86.44 per day, payable every 7 days to the court.
And why am I representing myself, sir?
Excuse me?
Why am I representing myself?
Why are you?
Yes,
I don't know that I can answer that.
you can't, because there's no legal counsel available for me in this state. So that's what I mean when I say I'm getting short end of the stick.
The escrow that you have to pay to the court must be paid in cash to the court. You can take it to the front window. They'll be more than happy to take it and give you a receipt for that. Pardon?
Okay. I'm unable to pay escrow today.
Ma'am? I ordered that escrow will be paid in the amount of 86. Do not interrupt me again. Escrow will be paid in the amount of $86.44 per day. It is due and payable to the court every 7 days. That's my order. I'll see you guys next week. Thank you, guys. What do you want me to call? Hamptons of Clover Lane versus Brenda Hampton. I'm just calling some. I'll get to Miss Williams in a second. I know you.
And there you have it, a marathon session in a Michigan courtroom where judge delivered some harsh lessons. Walter LaCroix, charged with operating while intoxicated causing death, tested positive for cocaine just days after his arraignment. His excuse? He used it and then disposed of the tray. The judge revoked his bond and remanded him, saying, "I can't let him go back out there and kill somebody else." Jade Layton, a sovereign citizen who claimed she was kidnapped by police, had her motion to dismiss denied after the judge noted that all delays were at the defense's request. And Elizabeth Kurtz, fighting an eviction from an extended stay hotel, was ordered to pay daily escrow and file a written answer, with the judge making clear he resented her claim that she was getting the short end of the stick. The broader implication here is crucial. Excuses don't work in court. Whether you're facing a felony charge, a sovereign citizen rant, or an eviction, the judge expects you to follow the rules. Test positive after being charged with a fatal DUI? You're going to jail. Claim you were kidnapped without evidence? Your motion gets denied. Say you're getting the short end of the stick? The judge will remind you that everyone gets a fair shake in his courtroom. If you found this case breakdown as eye-opening as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. We'll see you in the next session.